Welcome to week 3. This week we will be looking at more grammatical issues in legal drafting, focusing on complex aspects of sentences so that we can explore some of the common errors. So this week we need to head back in the direction of statutory interpretation and look at Latin maxims. Why do we need to do this? Well, it's because Latin maxims are based on the grammatical arrangement of the words. They can apply to sentences in a contract or a trust deed, just as they apply to the provisions of a statute. And the first one that we'll look at is Iusdem Generis, which basically operates on the basis that where there is a list of 2 or more specific items and then a general phrase at the end of the list, the general phrase takes on the characteristics shared by all of the items in the list. So look at the definition of the word pest on the slide there. Applying Iusdem here, you can see that the characteristic or the commonality between the specific items, which are mouse and rat, is really a rodent. So that would then mean that the general phrase, other similar creature, also takes on that characteristic. Now that might be too narrow in the circumstances. Now we probably think of cockroaches as pests, but does a cockroach fall within other similar creature? This is unclear. The use of the word creature suggests that Parliament perhaps intended something broader than just rodents. Now, when you're engaging in statutory interpretation, you can use the purposive approach to help you identify what Parliament intended, and thus whether or not it was intended that other similar creature would be broader than just rodents. However, in relation to contracts, there's no purposive approach. The courts adopt an objective interpretation of the contract. Other Latin maxims that might be relevant to the interpretation of a legal document such as a contract include Noscater and Exclusio Unius. Now with Noscater, it again involves a list of specifics, but in this case there's no general phrase in the list, only a list of specifics. Now if there is doubt about one of the items in the list, so there's a lack of clarity as to the meaning of one of the words within the list, this Latin maxim says that that word will take its meaning from the other items in the list. So the meaning of that word is derived from the words with which it is associated. That means that if you want to avoid a particular word taking on the meaning of the words it's surrounded by, you need to provide a suitable definition to ensure that doesn't happen. Turning our attention to Exclusio Unius est exclusio alterius, try saying that 3 times in a row. This basically means that express mention of one thing automatically excludes those things that are not mentioned. It's really a rule of common sense. So if you see a list of A, B and C, you can assume that D is not included. But its effect is actually broader than that if you're thinking about rights and obligations. So if you confer rights 1 and 2 on party A, it can be assumed that party B does not have rights 1 and 2 if they have not been specifically allocated those rights. You need to be particularly careful when you're drafting documents like contracts, partnership agreements and trust deeds, where you're imposing rights or obligations on the parties, because if you inadvertently fail to mention a party, or you inadvertently fail to mention a particular right or obligation, then it will be assumed that you deliberately left that out and that was the intention in the drafting process. What that means is that that party won't get that particular right or obligation that you have failed to provide them in the draft. So one of the huge drafting no-nos these days is the use of shall. As the study guide explores, this has multiple meanings and can lead to ambiguity as to which version applies. There are a range of substitutes you can use instead, such as must, will and may. Obviously which one is suitable will depend on the context in which you intended to use the word shall. Whenever you are drafting and you feel that urge to use shall, have a look at the study guide to see if you can find a suitable alternative instead. The thing that I wanted to concentrate on this week is punctuation, and in particular commas and apostrophes because they're frequently misused. A misplaced comma or the presence of an additional comma that shouldn't be there can be very costly. The reading this week explores the Canadian comma case as an example of that. The absence of a comma can also be a costly mistake too. So the New York Times article, which is listed in the reading this week, is about litigation concerning the absence of an Oxford comma, which led to a $5 million settlement. One of the problems that we commonly see in students' work is the fact that there is an overuse of commas. We tend to get comma happy as we're writing. This of course means that we are placing commas throughout the document in inappropriate places, as was seen in the Canadian comma case with its additional comma in one of the key clauses. The presence of an additional comma leads to a completely different interpretation to that which was intended, but a party subsequently argues for an interpretation different to what was intended at the time of contracting because it better suits their position later on in the parties' relationship. Note that even if we read the document how the author intended to convey the message, it still looks unprofessional to use commas inappropriately. So one of the consequences of being comma happy in our work is the comma splice. This is where we place a comma between two independent sentences. So you can see an example of the comma splice on the slide there, which says, "The jury found him guilty of the offence, comma. The judge sentenced him to 5 years in prison." So there are two distinct sentences in this one sentence. The first is the jury found him guilty of the offence. The second sentence is the judge sentenced him to 5 years in prison. They are two related sentences in that they are both part of an overall story about a court hearing, but they are independent. One is talking about a jury verdict, the other sentence is talking about what the judge later determined regarding sentence. Here, these two independent sentences need to be separated by a full stop. The comma is not sufficient here, it just splices the two sentences and does not join them together appropriately. So a full stop really is the correct solution for these two independent sentences. However, alternatively, if we did want to join them together because they're related, then we could use a conjunction to join them together. Here, the most suitable conjunction would be "and" to link these two distinct sentences together. The comma is not sufficient, but using the word "and" instead of the comma would be grammatically correct. Linked to this is also the idea of a run-on sentence. We regularly see these in students' writing as well. Now, instead of a comma separating the two sentences, as we saw in the previous example, there is no punctuation, no conjunction, no connection between these two sentences whatsoever, so they just run into each other. So the example shows, "The jury found him guilty of the offence, the judge sentenced him to 5 years in prison." Now, whilst when we say that out loud it makes sense, because our brain automatically puts the full stop in between the two sentences, when we read it on paper, it just looks like a constant stream of consciousness on the part of the writer. And what it conveys to the reader is that the document has not been proofread, because if it had been, the author would have noted that there needs to be a full stop between the first sentence and the second sentence. Or alternatively, there needs to be an appropriate conjunction joining these two independent sentences together. Also related to this topic are colons and semicolons. Again, these can often be misplaced throughout documents, and they can be quite problematic in the interpretation of a document. So make sure you check out the reading sections 2.84 to 2.90 for colons and semicolons, and also have a look at the study guide on this as well. So let's move on to apostrophes now. In legal documents, we tend to see mistakes with apostrophes less frequently than in student work. That's perhaps because in professional writing, we try to avoid the use of contractions like "it's" for "it is" and "there" for "they are," because it looks a little less professional. However, they're a significant problem in students' work, and perhaps this is through lack of attention to detail when actually drafting, or perhaps it's a failure to proofread adequately. But it's important to make sure that you understand the difference, so we'll briefly cover this now. So contractions involve taking two words and merging them together. The apostrophe symbolises the letters that have been removed as part of that process. So if you see on the slide there the word "shouldn't," the apostrophe symbolises that the letter O has been removed. Now, we use contractions every day when we speak, usually in text language and emails, But in legal drafting, we try to avoid them. It just looks a bit less professional. And so we would use the full version of the contractions you see on the slide there. So we'd use you are, they are, have not, here is, should not, it is. Okay, let's now contrast that with possession. So you can see on the slide there, we've got Jennifer's car. So the apostrophe and the S are added to the word Jennifer to show possession. What this really means is the car belonging to Jennifer. The second example there is my parents' house. Now in this instance, we're looking at the plural, it's parents. So we just add the apostrophe at the end of the S. And what we see there is that it's telling us it's the house belonging to my parents. Now this all seems pretty straightforward, but people seem to get confused when it comes to possession and contraction with the following words that you can see on the slide. These are the ones that are most frequently mixed up. So you can see in the column on the left hand side, we've got its, your and their. These all show possession. The other three on the right hand side are contractions. Now, if you don't know whether to use an apostrophe, think about the entire sentence. Could the sentence be rewritten so that you write they are rather than their, and you are rather than or, and it is rather than its? If so, you are looking at a contraction. Now remember that we try and avoid using those in legal writing just because it looks less professional. Now if you cannot write them in this manner, so you are, they are, or it is, then you're probably using the possessive version, in which case you need the column on the left. Now just to add complexity to the mix, a third there exists. So we have THERE, there is, there are. It also indicates place, so the car is parked over there. Or one of the most frequent things that we hear whenever we go anywhere in the car and we're a parent, are we there yet? As some of these types of errors are habitual, instinctive, or they're caused when we draft documents madly in a rush, you need to ensure that you've left time in your schedule to really carefully proofread your work so that you can spot those issues before you submit. Okay, that brings us to the end of the video for week 3. I look forward to seeing you in the workshop.